Good morning, everybody. I hope you can hear me and see me. My name is Ryan Shields. I'm the Director of Communications at VCOSS, the Victorian Council of Social Service, and I'd like to welcome you here today to our Renters' Rights Rundown event. Before we begin, I'd like to acknowledge that wherever you're joining us from today, you're joining from unceded Aboriginal or Torres Strait Islander land. So I'd like to pay my and VCOSS's personal respects to the traditional owners of the lands upon which we are meeting. For me, I'm actually joining the session today from Mildura. So I pay my respects to the Ninte and Latchi Latchi people, and respect to elders past, present, and to emerging leaders also. As part of that acknowledgement and that giving of respect, I'll just note in passing, VCOSS is supporting and encouraging a yes vote in the upcoming referendum on the Aboriginal Torres Strait Islander voice. And if you'd like more information about that, the website is there on the screen, yes23.com.au. So why are we here? I'm hoping you all know why you're here, because you've registered and attended, and I thank you for that. We're actually here to celebrate a birthday. For those who don't know, it is 2 years today since some rather sweeping changes to rental laws and rights and protocols came into place in the state of Victoria. For many of you here today, you will be across the detail. You might have done some work in this space and of course have been dealing with clients and people you support over the last 2 years to understand those laws and those changes. Others may be new to the sector or new to this space, so you're coming at this a bit more fresh. Either way, today's session is to do a bit of a recap, a bit of a refresher for those who are a bit more advanced along, but also for those who are coming at it perhaps for the first time, to bring you up to speed on what those changes are, so you can go about your job and support and assist and help people in the best way possible. So the agenda for today is a very simple one. We probably don't even need an agenda, to be honest. Very shortly, I'll be introducing and throwing to Ben Cording from Tenants Victoria. He is an absolute expert in the field and is all across the detail of these changes, and he'll be giving a formal presentation, going from the history to the now to the how we deal with what the complexities are that are still in the system. And then after that formal presentation, of course, we want your questions. We want you to put your question in the Q&A function of Zoom. And then Karen Taranto, who I must give credit to, is the absolute driving force behind this Renters' Rights Rundown series, is in the back end today, collating and synthesising and distilling your questions and your queries and feeding them through to Ben and myself, and we'll go through, or Ben, I should say, we'll go through the process of answering those as best he can. I will just clarify as well, feel free to throw questions into the Q&A while Ben's speaking during his presentation. We won't answer them, of course, until that later section, but it's good to put them in and to submit them at that time. And like I say, Karen can go about the business of distilling those and synthesising those a little bit. If it hasn't been obvious already, we do have Auslan in the session today, Alex and Neil, shout out to them. Hopefully they're on your screen and you can see them. You can pin them if you like as well. Like I say, there are 2 Auslan interpreters, so they'll be jumping in and out and changing, but you should be able to pin both of those as you go along. We also have captioning, live captioning available during today's session. If you don't already have that set up, you need to go into the caption menu down the bottom, just in the main menu bar of Zoom, and just enable that captioning so you can see it. We are recording today's session, video recording. So later, a couple of days from now, we'll be able to distribute that video recording, and we'll be going through the process of formally captioning that as well, but also providing a transcript of today's session. So hopefully, you gain a lot of knowledge and you get a lot of your questions answered now, but you can also refer to it and use it as a resource as we go through. I actually want to, just before we start, I'm actually going to throw a bit of a question out. We're going to do just a very short poll, and it's literally a 1-question poll, so hopefully not too onerous. And you can see it there on the screen. We're asking just what issues do people most need support for? It's an obvious question, but it's something which there have been some survey work done on in the past. But of course, as we know, this space is ever-changing, very busy, very heated right now. So we're very keen to know if the responses we've gotten in the past perhaps are still the ones we're talking about today, or whether other ones are emerging as dominant themes and issues. So I can see some of you voting in that poll for now. That's great. Thank you. We'll leave that open for a minute or two, and then we'll move on. And the next stop we have is, of course, me getting out of here, getting off screen and welcoming Ben Cording. So Ben, like I said, is an absolute subject matter expert. He's a senior lawyer at Tenants Victoria. He is a veteran, dare I say it, of sessions like this. And you're in great hands with him today. So welcome. And yeah, I'll throw over to you, Ben.
Thanks so much, Ryan. Well, look, given we've only got a brief period of time, I'll jump into sharing the slides. And just while I'm doing that, I've got you cannot start the screen share while other participant is sharing. Let's try that again. There we go. Okay, thank you. So just a bit about me personally. I've been doing this for almost 12 years now. Prior to that, I did a bit of prison law, did domestic violence, used to be a school teacher, spent about 6 or 7 years doing disability direct care support while I was going through uni, and did a bit of youth work in that time too. So very grateful for your time here today, and hopefully this, I guess the main message is that we want to support people as much as we can through the legal issues. It is important to identify that a lot of the issues that people are facing at the moment with renting is probably a political issue, it's an affordability issue. And it's one that we, are very, very grateful for VCOSS inviting us to talk to so that we can work more closely. We know that there are lots of renters that are missing meals, they're going hungry. It's a really brutal time. So we want to try and equip people as best we can. I myself am on the lands of the Yallock at Willem. So I want to acknowledge elders past, present and emerging and pay my respects to people, connection, land, sea and community, and commit ourselves to justice for First Nations people. So this is not a substitute for legal advice, but you can see here there's an admin number. One of the main messages that we really want to get out to the community workers, social service network, is that we have an advice line. You can call that as much as you need. It doesn't matter if you're just confirming something, if it's a really complex matter, you can contact us if it's about a renter and you're an organisation supporting a renter. So don't be a stranger. We really do want to hear from you. There's plenty of space in there. It's a lot easier than calling through our advice line. We find that most renters calling us might have to wait anywhere from 20 minutes, half an hour. So it's certainly an advantage for you to be able to train yourself up by regularly calling that line. So you can just say, I'm from this organisation, and they'll either look to put an appointment or get you straight through to a lawyer. So just a bit about our service. If you don't know, Tenants Victoria was started in sort of mid-70s. There's about 2.8 million renters in the state at the moment. And that's obviously growing. So we provide free legal help and advice. So we do education sessions. We do roughly anywhere from sort of 12,000 advices a year just over the phone. And we do several thousand email advices as well. So if people are trying to get an email advice through to us as a renter, that can get sent through, but we take about 10 a day. The other thing that we do that's helpful is that organisational advice line. So if you want to seek advice as an organisation, you can also just email to our admin line saying organisational advice, this is what I want to know. And we can get in touch if we need any further information, or just give you the information that you can give to your client. So as Ryan said, we're going to talk about a lot of the changes that happened 2 years ago to the day. There's actually some new changes that come in right today, which includes making sure that every house in Victoria now has got a safety switch. So your kids can't jam a knife into the wall socket and get electrocuted. I think that's good news. We've still got a long way to go with some of the things like minimum standards, but we do now have minimum standards. We're going to talk about some of the tips for renters and about going to VCAT. We know that most renters are really scared of going to VCAT. So VCAT, if you don't know, is the Victorian Civil and Administrative Tribunal. The main thing with VCAT is that it's very user-friendly. Most people represent themselves, and it doesn't matter whether you win or lose, you don't have to pay any legal costs. At the moment, most hearings are still being done over the phone, which can be helpful in some ways, not helpful in other ways. Okay, and then we'll talk about some of the services if you're not able to get onto us. So let's look at the changes. So firstly, in eviction. One of the major changes is that they removed the no reason notice to vacate. You used to be able to get a 4-month notice, essentially saying, I don't have to tell you why I'm kicking you out. I'm kicking you out. That's gone. Yay. The other thing that they've limited is at the end of a fixed term notice. The end of a fixed term can only be given during the first fixed term agreement that you're given. After that, they can't do it. So if it's a second, a renewed lease, they can no longer use this notice to vacate. You can also challenge this notice to vacate if it's retaliatory. So I ask my oven to be fixed, and then mysteriously out of the blue, you get a notice to say, oh, I'm ending your fixed term agreement, 3 weeks later. You can argue and go to VCAT and say, the only reason you want to kick me out is because I asked for my oven to be fixed, or because I said you weren't able to come in whenever you wanted. So that's important. Another shift has been with any notice to vacate that's for no fault. In most cases, they need to provide the evidence when they're asking you to leave. So if they're saying, for example, they want to do repairs and renovation, and that's the reason they want you to go, they actually need to show quotes. They need to show how long the works will take. They need to show, that it's necessary that the renter actually has to move out and that the works can't be done while you're still living there. So that actually gives renters a lot more leverage to look at why they're being kicked out. And then finally, one of the other big shifts that we've seen has been the introduction of what is called the reasonable and proportionate test, which means that it used to be if the rental provider could, for example, prove that they wanted to move in, or that they could prove that you breached what's called a compliance order, saying you must do this or must stop doing this, and you'd not obeyed the order, then the tribunal had no choice. They had to kick you out. Now, even if they can prove the reason that they want to kick you out, there's still this question of the hardship, the relative hardship between the parties. So it's not a perfect test. It's not working as strongly as we would like, but it certainly is stopping some evictions where it's really not necessary, or it's exposing families to a really severe risk of immediate homelessness. So it is a work in progress. It's developing, but it also means that the hearings are taking a lot longer. And it's also more important for legal services and for social services to try and document what our clients' background, experience, mental health is, of what will happen if this family, this person is rendered homeless. So hearings are taking longer, and we know that VCAT has got quite a backlog still, and they're working their best to sort of move through that. Continuing on eviction, there's also been the introduction of the threat and intimidation notice. This was actually introduced quite a lot earlier as part of sort of the COVID laws. Some of the rental laws changed during COVID, and this was introduced, and we've already seen a lot of these notices to vacate. Community housing has been really grateful because it's been given sort of some leverage to go, look, if you're going to threaten and intimidate our staff or our tradespeople or the rental provider, that's sort of the scope of what it's limited to, then they can give this notice. You can also challenge this notice to vacate as being retaliatory. So someone might be arcing up and getting, I'm really frustrated that you're not listening to me, and I think that you need to leave now, and the person refuses to leave. There's again, it's not a sure thing that someone's going to get evicted. So be prepared that you'll probably see a lot of these threat and intimidation notices to vacate, and we'll talk about what you can do shortly. Following on from that, there's also been the introduction of being able to give compliance orders instead of evicting someone. So previously, if you had definitely said, yep, you're causing a danger, and they want to try and evict you, they had to evict you if they could establish that the danger was there and it was ongoing. Now, in some circumstances, they might be saying, well, look, is it reasonable and proportionate you get evicted? Maybe not, but what we are going to do, instead of evicting you, because I have found there's been a danger, I'm going to make an order saying you must not do this. You must not be abusive to the neighbours or whatever. And so you can get a compliance order as an alternative to someone being evicted. So that's probably the main shift, particularly for, I don't like using the language, but antisocial behaviour. Trying to create very clear lines. So if you get someone that's facing a notice to vacate, we really encourage you to contact us straight away to get advice. Early advice is going to be a lot more helpful. There's also been the no pets notice to vacate. Despite the name saying no pets notice to vacate, it's actually only able to be given if you've got an order from VCAT saying you must not have a pet. So the PETS framework has been with us a little bit longer, and that PETS framework is essentially saying that a renter can make a request. It's 14 days run. If the rental provider says no, they can't just say no. They actually have to apply to VCAT to prove why it's not reasonable for the person to have the pet. And so the vast majority of pet decisions that have gone to VCAT have been successful in favour of the renter. This framework doesn't apply to things like guide dogs, but therapeutic animals may still fall within that framework. So it is important to run through. There's also been a lot of action to bring in anti-discrimination laws. So a lot of the Equal Opportunity Act has been brought into the space of the Residential Tenancy Act. You can actually seek compensation for discrimination. It's unlawful to discriminate when people are applying for properties, and we certainly know that discrimination is a very real thing for a lot of people when they're applying for properties. So that's an area that we now have to skill up on, and also to identify. So just quickly with discrimination, it doesn't matter whether someone intends to discriminate or not. So it's certainly worthwhile being aware of the conduct and the basis of the decisions. For other people that may want to tell their story but may not want to necessarily take legal action, the Victorian Human Rights and Equal Opportunity Commission also has an anonymous Tell Your Story platform. And that's really important for you and for your clients to be able to share if they've experienced discrimination and they want someone to know about it. For example, they might go around and give everyone an application form to the property except for you, who's a person of color, and you're like, what's going on there? That's not okay. All right. So just in terms of if you're a newbie to the sector, that's totally fine. I'm many years on and still feel like I don't know everything. Any time that a rental provider wants to get a renter to leave, they need to go through this process, which starts off with a notice to vacate. One of the most important things that our clients need to know is that it'll have a termination date. It might say, for example, you have to leave on the 1st of June. The renter does not have to leave on the 1st of June. A rental provider can never themselves change the locks and just say, you're out, too late, I'm not going to VCAT, stuff you. That would be illegal and a serious offence, which you can report to Consumer Affairs. You can also go to VCAT to get yourself back in if you have been locked out. Again, call us. So it starts off with this notice to vacate. The renter can stay beyond that termination date. Nothing magically happens. The tenancy keeps on going as normal. You keep paying your rent. That then forces the rental provider to apply to VCAT to say, I want an order, what's called a possession order, to get the renter out. At the hearing, the tribunal will look at a number of things. They'll look at service. So a notice to vacate can't just be slipped under the door. It's got to be given by registered post or by hand or by email if the renter has agreed to receive them by email. So the reason lawyers get really excited about the detail is because if they stuff up this process, they won't get their possession order. So if they send it via email and the renter never said, I'm okay with email, then they won't be able to get their possession order. And that's the sort of things that we look for, to try and give people more time to try and knock out a notice to vacate so the renter's got a home. So they look at the grounds, they look at the evidence. So the rental provider is the one that has to prove why they want the property back. And then even if they prove that ground, then the tribunal will look at this reasonable and proportionate test. There are a few defences where the renter might have done something, but in most cases, you're really looking at the balance and whether or not the landlord can prove their case. If they fail, the possession order's dismissed, which means nothing happens, rental agreement continues. If they grant the possession order, even if you've got a renter that's in a lot of arrears, for example, which we'll talk about in a moment, you can ask for more time. So the maximum the tribunal can give is up to an extra 30 days to delay what's called a warrant of possession. And that warrant is not criminal in nature. It's just a piece of paper that authorises the police to do the eviction. So the police are the only people really that can do evictions. If it's been an eviction and the police haven't been involved, it's probably an illegal eviction. Again, in doubt, give us a call. So with rent arrears, there has been some changes to the rent arrears framework, but they're not significant. So if you don't know the rent arrears framework, once someone owes more than 14 days worth of rent, they can be given this notice to vacate. And so that's 14 days in arrears. For example, if I pay my rent at the beginning of January, that will pay for the whole of January. It won't be until the 15th of February that they can actually give me that notice to vacate, saying that I'm 2 weeks living there where I haven't paid. That's what arrears are. Once you owe that money, under the new laws, if you pay off all the money you owe before the termination date in the notice, it goes away in most cases, but most people aren't able to do that. If the person hasn't paid it off and the rental provider applies to VCAT, you'll be given an opportunity to go to VCAT. And this is the thing that a lot of renters don't know. They may choose to leave because they're so scared or they don't want to go to VCAT, but they have a right to ask for a payment plan. And so if you want a payment plan, there's really two main things you need to show. You need to show that you're able to sustain the rent and then pay off the money that you owe over a reasonable period of time. During COVID, we saw Justice Quigley, who's the president of VCAT and also sits in the Supreme Court as a judge, essentially say that in some circumstances, particularly around the pandemic, giving a payment plan over a period of a year may in fact be reasonable. And that's a lot longer than we've ever seen. Now, we're not quite post-pandemic, but obviously people are working again, but there's really nothing to lose by asking for the payment plan. If you're not successful in proving the payment plan, then you can ask for that extra time, the extra month, and that can be really important in terms of accessing many of your services that you guys run. So any homelessness access, because again, getting listed for priority, putting in your housing applications and all those things are much more effective, obviously, when there's imminent homelessness. So that's largely the rent arrears framework. So what has changed? The thing that's changed is, it's not called this in the law, but it's called 5 strikes. That's what I'm calling it. If you get 4 notices to vacate, on any one of them, you can be evicted. But if you end up for any reason within a 12-month period, which rolls over on the anniversary since the agreement began, so right when you started, so if you start on the 1st of March, this will reset the 1st of March each year. That 5th notice to vacate means that you're not able to get a payment plan. And also you can't get financial advice. So one of the other powers that you can now have is that VCAT can refer you off to a financial advisor. There are meant to be prescribed financial advisors. There are none. So many of you that do financial advice, we're incredibly grateful. A letter from a financial advisor can be really, really helpful because it will identify the issues of what's happened, so how the arrears accrued, and it will also make the recommendation of what the reasonable amount is that the person can afford to pay off over time. And the VCAT will take those letters pretty well, and it also protects a lot of the financial information for the renter. So there's a balance there. So that's largely the rent arrears process. You just need to make sure the person hasn't got any 5th notice to vacate. Any money that's covered under a payment plan won't give them grounds to give another notice to vacate if you think there's a sneaky landlord trying to get to the 5th notice to vacate. But you do need to just make sure that regular falling behind in the rent can actually be a little bit more dangerous than it used to be. So financial counselling, we strongly recommend people do get financial counselling if they can. We know that sometimes that can be hard, but certainly it's really helpful. Just as a quick plug, the government has reintroduced the energy comparison $250 thing again, and there's also what are called utility relief grants. As utilities become more expensive, the utility relief grants might be quite helpful for a lot of your clients, and that can give you quite a bit of money off over a number of utilities, rotating I think every 12 to 18 months. So check that out as well. All right, so just some of the other changes quickly, and then we'll jump into some questions shortly. Just when you're starting the agreement, rental bidding is illegal. It's illegal for a real estate agent to say, hey, I've got an offer for $320. Do you want to give me $340? That would be illegal. Yep. I love the sign for this. Yeah. There are mandatory disclosures. So when you move into a property, they need to tell you, is there building permits? Is there going to be construction next door? Is there asbestos in the property? Has there been a homicide in there? Has there been a major drug dealing in the last little while? So there's a number of things they need to tell you positively, and the renter doesn't even need to ask, which is good. There are also some questions which are prohibited. So they can't ask about your personal attributes. It doesn't matter whether I'm a boy or a girl, or if I'm intersex or non-binary. They don't need to know that. Why does that matter? If they do ask about a protected characteristic, they need to provide an explanation as to why they want to know that particular characteristic. How is that relevant? So why do you need to know if I've got a partner? Why do you need to know if I've got children? So it's an interesting framework. There's not a lot of decisions from VCAT around that yet, but that's really helpful. When they're asking for documents as well, they can't ask for your bank statements and go through all of the things you've been spending and go, oh, I can see you owed a little bit of money here and you bought the kids ice cream. Oh, kids should have ice cream. It's really important. And then what are the other things? So there's a few other things in the prohibited question. So just be aware of that. Misleading and deceptive conduct, that's now been introduced. It's a really good idea to save the ad when people go for a property, just to make sure that there's nothing that's misleading. If they have been misled, they may be able to get out of the agreement if you do it very early. So call us for advice on that, or they may be able to get compensation. So if you say, oh, there's on-street parking, there's no on-street parking and you're in a wheelchair, that's possibly a deal breaker. So, you know, it might be things like that. There's now minimum standards. So minimum standards, you need sufficient hot and cold water in the laundry, kitchen, bathroom. House should be mold free. That's a good one, because we know there's plenty of mold issues. The house should be structurally sound, weatherproof. It's got to be a heater that needs to be energy efficient in the lounge room. There's a little bit of transitional work over there in the next few years, but if there's no heater, there's got to be a heater that's energy efficient. We've seen that, so the bins, they've got to provide bins. So there's a lot of things which are pretty common sense. So the bar's not particularly high, but if a house doesn't meet the minimum standards and the rental agreement has started since the 29th of March 2021, then you can treat it as an urgent repair. So you can get into VCAT within 2 business days. So that's how quickly urgent repairs are listed. We've discussed the Equal Opportunity Act, so that's been brought in there, and that also applies to when someone wants to transfer the agreement. So we know lots of people want to get out of their leases. We know lots of people are trying to get into their leases. If someone's being discriminated against in the transferring of their agreements, that's something you can also raise with VCAT. Renters now are given a copy of the keys for each renter. So if you've got 5 renters, that's 1 set of keys for each of those renters. So it'll be a total of 5 keys, and that includes fobs to access common areas. One of the other things that shifted, which is a major shift for the disability community, is that there used to be community residential units, specialist disability accommodation, similar things, and they've now gone from the Disability Act and been inserted into Part 12A of the Residential Tenancy Act. So it is not a very common accommodation type, but clients with a significant impairment that might be eligible through the NDIS can be given accommodation in this. And you can actually get a normal tenancy agreement or an SDA agreement. And the SDA agreement, in my opinion, is significantly better and more protective for people in those environments. We'll just look quickly at during a rental agreement. So you've got to clarify the duty of good repair. So it doesn't matter when you move into a property, whether it was broken when you moved in. If it's in the property, it should be working the way it was intended. And if it's not, it's probably going to be a repair issue. We've talked about the PETS framework and therapeutic animals as well. Modifications. Renters can now look at making modifications to their home. There are some that they need permission for, and there are some that they don't need permission for. If they need permission, the law says that you can't unreasonably withhold consent, and that things like safety, so that's massively important for family violence, and also energy efficiency. So there's quite a number of modifications, and if you can't reach an agreement, you can go to VCAT, and they have to list that within 5 days, 5 business days. So just with modifications, be aware that it's just about consent. So if you put lots of holes in the wall, you're still going to have to fix it, you're still going to have to paint it, and you still might have a dispute about it. So do be careful around making modifications unless you reach a written agreement. Otherwise, you do have to restore the property to its original condition, save for fair wear and tear. Cool. All right, so other things during the agreement, they've got to do gas and electrical checks. So that's just kicked off from today. And that's got to be done every 2 years. So that's for all the gas and electrical appliances. And that's one that I think will be pretty challenging for a lot of rental providers, just to make sure their house is safe, but a really important one. Any appliance that's replaced has to be energy efficient. There's a framework now for rental providers, if they want us to sell the property, to come through and take lots of photos and video. Again, there's a framework for renters to object if they think it's private information, it's exposing someone. So if it's family violence client that you've got, there's a specific framework where they can say, hey, I'm family violence. This is the things that I really don't want you to take photos, or I'm not okay with that. And so there's no decisions clearly on how it works exactly at the moment, but that's there. There's also a framework for open inspection. If you move into a property, they don't tell you they're going to sell. They can give you a form called a notice of intention to sell, and the renter can look at getting out of the rental agreement by giving giving a 14-day notice regardless of whether or not it's a fixed term. If the renter does have open inspections, they get at least $30 a day or half a day's rent for each open inspection. So it's better than nothing, but it is a frustrating thing for people in terms of experiencing the open inspections. Certainly we expect that there'll probably be a lot of sales where people may foreclose or not be able to afford their rent. So if you have a client, and this is just an aside, if you have a client and someone from the bank knocks on the door, or someone from the bank's lawyers knock on the door saying, hey, just letting you know there's some issues here, that's probably a good flag to seek advice early. There is the notice to vacate by a mortgagee, which is a bank, is now 60 days. All right. Finally, when you're wanting to end the agreement, there's now frameworks that if you're offered a housing in public housing or community housing, that's been added, or you're fleeing into crisis accommodation, you can give a 14-day notice irrespective of the fixed term. So you do need to provide evidence of the offer or where you're heading, not the address if you're in family violence, because that would be a bad idea. And so that's helpful for people. And again, if they're selling there and they've given this notice of intention to sell, you can get out of there. Consumer Affairs now issues guidelines. So who has to clean the gutters? It was unknown. Now there's a guideline that says it's the rental provider. It may seem a little bit silly, but actually when there's major flooding and the water comes in over the gutters and then that goes into the house and floods the house and causes massive damage, it can be quite a big compensation claim, and it's helpful to know who's responsible for the gutters. Just aware of time, the bonds and compensation. So we know that VCAT has got quite a significant delay in bond and compensation claims. With the bonds now, so all bonds in Victoria have to be lodged with the Residential Tenancy Bond Authority. It generates millions of dollars that contribute to the running costs of VCAT and a few other things around in relation to residential tenancies. Unfortunately, rental providers don't have to pay bonds. In circumstances, we see that the Residential Tenancy Bond Authority now allows you to apply directly to the RTBA to say, I want my bond back, and then it starts a clock running. The rental provider's got 14 days to make a claim to say, I object, and that ability, a bit like the PETS framework, is that they actually have to apply to VCAT and say, I object, and here's my application to VCAT to prove that I object, and they have to set out what they're claiming and how much. Just briefly on bonds, if you're not aware, a bond claim for a renter is free. They should make their claim pretty much as soon as they move out, either to the RTBA or if they know there's going to be a bun fight to VCAT. If it's going to VCAT, the main issue that renters face at the moment is time. But just briefly, you look at your condition report. I didn't do it. It was already there. You say, okay, fair wear and tear. That's my argument. I think it just broke from normal usage. Or you say depreciation. So carpet, for example, lasts 10 years. If you can prove that it was 8 years old and you did do damage to it, you're only liable for 20%, the remaining amount. And it's not the whole house, it's just the room. So a lot of people try and bully. We're seeing a lot of arbitrary claims as rental providers are really financially stressed, and a lot of penny pinching. So it's up to renters how they want to approach that. Previously, there used to be a 6-year limit on when you could take action. So when a renter wants to claim compensation, they can do it after they've moved out. They've got 6 years from when the issue happened to make the claim. Now, as a result of a very strange decision from the Victoria Supreme Court involving a circus, it's now no longer 6-year limit. So you can actually make a claim whenever. But look, the sooner you can make a compensation claim, the better. Just quickly on family violence. Family violence has changed quite a bit. The main thing that you need to know is you don't need a final intervention order. In fact, you don't need an intervention order at all, albeit it still can be very, very helpful, particularly an exclusion clause so the other person doesn't live there. But all applications have to be listed within 3 days. So it's really, really quick. You used to have to wait around for 2 or 3 weeks. Now it's 3 days. So the main decision for people that have experienced family violence is, do I stay or do I go? There's also some consideration that if I want to stay, in order for me to stay, I have to be able to afford the tenancy. What we're seeing, and this is probably true in a number of spaces, is that living on your own and affording the rent might be very difficult. And so you'll see on the family violence, there's a specific family violence application. You can actually also bring another tenant on, so someone you might feel safe to live with, that you could subsidise the rent and it would become affordable where it otherwise wouldn't. And that's a really important thing for people that are experiencing family violence, because they may be financially dependent on the perpetrator of the family violence. If you're not familiar with the MARAM framework, that's MARAM, look it up. It's a whole big government package. Hopefully many of you are well indoctrinated with MARAM and the tools associated with it and your obligations in some cases. But be familiar with that. So family violence can also be a defense to certain notices to vacate. So if you got, for example, a danger notice because your partner was having a go at you and threatened someone else in the course of that, there are actually now some defenses there. Another feature of the changes is that in the modification framework, you can put in, things for security. So it also specifically mentions CCTV cameras. So you don't need consent for a CCTV camera that's not hardwired, and there's plenty of Wi-Fi plug-in cameras now. And there's also, if you want to get a proper full system that's hardwired, you do need permission. It's got to be done by a qualified person, but that's there. With a family violence, if there's a contribution of the bond between each person, the person can say, hey, I've experienced family violence and that's why the damage is done. You can actually try and protect your share of the bond to say, I'm not responsible, please protect my bond. And VCAT has done that a number of times already. Probably the main take home I would suggest is that if someone's looking at leaving a tenancy, you really need to go to VCAT to either get the creation to put a new tenancy in your name or to terminate it. And the reason is that if you just flee and then the tenancy ends and the keys go back and there's damage or there's rent arrears, the person that's the victim survivor is still exposed to some potential liability. Whereas if you go through the creation or termination process, they can apportion things like rent arrears, which is new. They can apportion damage to say, actually, that's got to be paid for specifically by the perpetrator of the family violence or the alleged perpetrator, depending on how it's substantiated. So that's a really important thing. If you're not familiar, we have a family violence kit there as well. Just lastly, there's this very strange thing that if your rental provider lives in another state, so it doesn't apply to Northern Territory or Australian Capital Territory, that you may actually end up going to the magistrates court. There's this weird constitutional thing. It's a legit thing where in fact they have to go through the magistrates court. There shouldn't be any other additional costs, but it can be a little bit more technical and a little bit more overwhelming and a bit more intimidating for renters. So just be aware of that. There's a link there for you. Lastly, rent increases. Rent increases a massive issue. In regional areas, rents have gone up almost about 20%, so it's pretty huge. They can't increase your rent more than once every 12 months for most tenancies. If you've been a periodic tenant in the same place since the 19th of June 2019, it might be every 6 months, but by and large, 12 months for most people. If you get a notice of rent increase, the only thing that a renter can do is to apply for a free report from Consumer Affairs to see whether or not it's excessive. And there's a number of factors they look at. They do not look at the hardship on the renter, unfortunately. We obviously advocate for a fairness test because at the moment things really do feel very out of control. But the important thing is that if a renter does nothing, say for example, my rent's $1,600 and they jack it up to $2,400, then if I do nothing, the rent increase will be effective. And I think that's why. So you've got 30 days from when you get that notice of rent increase to get the report. If the Consumer Affairs person, they call up the renter and say, hey, I want to have a look at your property. And then they come out and they inspect it, they'll give you a report. If the report says it's excessive, they'll talk to the real estate agent and say, or the landlord saying, look, do you want to do this? Because we think it's excessive. Some landlords will withdraw. If the rental provider doesn't withdraw their increase, then the renter needs to go to VCAT to fix it. And in most cases, VCAT will follow that. Some increases we've seen have been incredibly excessive, but there is still that capital inflation rate, which is quite massive. So, we don't want to be unrealistic, but it is really important. You don't have much to lose. The report is free. If you're in financial hardship, you can ask for a fee waiver at VCAT. So just in terms of tips for renters, don't pay anything in cash. Take photos when you move in and out. If you've got repair issues, continue to pay your rent. There's this thing that's been around for a while, but it's changed, the rent special account. You pay your rent to VCAT instead of it going to the rental provider, just as an incentive. And watch out for scams. There are a lot of scams around. So just in terms of, how to resolve stuff, identify your rights. So have a call, try and negotiate. And if you can't negotiate, don't be afraid of going to VCAT. So VCAT, they're interpreters, they're free. The person at the front's called a member. You don't have to be a lawyer if you want to represent, but you do want to be careful. But you can go as yourself as a support person. The cost is $67.40 at the moment. If your client's on a healthcare card or otherwise, it's going to be free. And like I said, regardless of whether you win or lose, no legal costs involved. So it's about confidence and about sort of trying to coach our clients to be brave. That's a lot of the battle. Multilingual resources are on our website and on VCAT's website as well. And this is just a really simple example. You don't have to use fancy pants language. There's a guide that tells you what section, or if you don't use the section and it's clear what you're doing, urgent repairs, just tell them your story. And often what we tell clients is show your story. Show me the evidence, take a photo, stick a thermometer, however you can get that evidence to show them that it's broken, that's fine. VCAT's very, very informal about that. And if they need more evidence, you might end up getting adjourned. All right. Then there's a bit about tenancy advocacy. So they assist with social housing. Tenants TAPS, they help with private housing. Tenancy Plus program helps with social housing, so that's community and public housing. Community legal centres, you can try them, and legal aid, and of course we're there as well. And now we're at questions. Apologies for a little bit over time, but hopefully that gives you a bit of a sense of what's going on.
That is fantastic. Thank you very much, Ben. I told you all we were in good hands. And I absolutely want to hear about that circus case that's at some point in the future, but maybe not today. Sure. We do have lots of questions. I just want to flag up front, we're probably not going to get through them all just because there are so many, but Ben does love homework. So I do love homework. Any that we sort of don't get to today, we'll try and get some responses and send them back through to you. Then we might just start with and I will also say some of the resources that Ben has mentioned in passing, things like MARAM, the power saving bonus, and others, will include details of those when we send out some communications after this event also. Ben, we have had a number of questions to do with the minimum standards themselves. So we will send out where to access a resource detailing those. But one question was specifically about air conditioning. You mentioned heating and other things, but is air conditioning required?
Nah, it didn't make the cut, unfortunately. It's one obviously that we think is really important. We know that heat is something that actually causes massive health issues, and certainly we'd be making submissions around saying that this is more cost effective for the state and just generally better for everyone. Like the heat stress that can, it can result in death. It does result in death. I think it's not a well understood thing within the community about air conditioning not being a luxury, but as we have more extreme weather, that it becomes such an important thing. But unfortunately at the moment, no, it's not a minimum standard. If it is there and it's broken, urgent repair. It's now deemed as an urgent repair, which is helpful. It didn't used to be, but yeah, if it's not there at all, unfortunately there's not a right to get that as part of the minimum standards.
Yep, unfinished business, as we say. Another questioner has asked if you can clarify by hand. You spoke about some notifications having to occur by hand, and they ask, does this mean just a door knock or to physically hand it to a tenant, or just putting in the letterbox? Is that enough? What's by hand?
Sure. So chucking it in the letterbox, not good enough. Slipping it under the door, also probably not good enough. So there's a whole bunch of laws around what service actually looks like when it's given personal service. Usually you'd be at a point where you'd be able to see the person, know and identify the person. In the court environment, they do what's called an affidavit of service, which essentially says that I am the person that gave it to them, and this is how I gave it to them, and I know that it was in their hand and it's been brought to their attention. So chucking in the letterbox, no, that's not going to wash. Under the door, also probably not going to wash. If you've got any concerns, give us a buzz and we can talk through what the exact narrative is.
Great, thank you. And the changes to eviction that you've been running us through today, how do they relate to temporary housing and transitional housing?
Oh goodness, sorry, they're big questions. So temporary crisis accommodation was a really big surprise. There was a lot of debate around this, but it used to be like once you were there for a property more than 14 days, you'd sort of fall under the residential tenancy. Now it's actually unlimited, so there's no time limit. If the place is defined, and DFFH funds the vast majority of temporary crisis accommodation, then that person could be there for months now, and that's what we're seeing as a major feature of the system, is that we know transitional is backed up. We know the temporary crisis is backed up. The whole system is very backed up. And there's a lot of, I think, local councils as well grappling with what the resolution might look like and what they can do. But a lot of it is around, state-based funding and where to put that money to, allow people to transition. So we would encourage people, if you're not sure what their rights are, because sometimes people end up in crisis accommodation and they don't know. Transitional accommodation is covered by the Residential Tenancies Act. So if you're in transitional, there are some recognitions of those rights. And again, we'd probably want to see exactly what's going on just to clarify. Sometimes it's not clear, what the arrangements are when people are living in hotels or other situations. So, yeah.
Right. One of our questioners is curious about the retaliatory action that you mentioned, which is not allowed, and you referenced it can go to VCAT. Ultimately, it's going to be one person's word against the others, right? A bit of a classic. How does that get resolved?
Yeah, sure. Look, it's a really good question. So it's largely circumstantial, and so often you look at the events objectively of what's happened, and so commonly it will be you had an argy-bargy about not letting them in, because you didn't think they gave you the proper notice, or you did. Like, it is often that simple. You ask for urgent repairs to be done. The rental provider goes, "Nah, I'm going to teach you a lesson. Here's your notice to vacate," and you've got to look at the proximity of time. And so it's an inference of credibility that when you get, say, for example, a notice that's an end of fixed term, one of the major questions we ask is, well, what's going to happen to the property afterwards? You're just going to let it to someone else. So it does beg a question of going, well, if you're just going to put the property back on the market and you've already got a tenant, what landlord would incur the unnecessary expense, go through the palaver, the gap, the reset, unless something weird is going on or they have a genuine explanation? And so we have to probe through cross-examination, asking the questions, going, what's you going to do with the property? And the members, they can, if it smells foul, it's a bit of a sniff test sort of thing. So, but again, for the renter, there's two options. You can challenge it preemptively. So as soon as the issues sort of happen, you get the notice, there's a window of time where you can make the application, or you can wait until the rental provider makes the application for possession order, and you can run the defense and say, okay, you want possession, I say retaliation, and then the VCAT has to decide. So it's a bit of higher stakes if you're doing it that late stage, but obviously if they're going to try and reserve a different notice, it's going to give you a bit more time. But that's the benefit with the initial fixed term. They can only do it once, and they've got to do it 90 days before the end of the agreement. And so once you get through that sort of dating period of the first fixed term agreement, that's off the cards. And then any notice to vacate they give has to have reasons behind it, and the rental provider has to prove it. And that's a big change for renters in terms of the confidence of going, I can use my rights, and I know you can't just kick me out for no reason. That's a huge mental transition for renters to know and be confident. Yeah,
wonderful. Another question here about mold. The questioner asking, can a renter challenge or organise, I guess, or request their own mold tests or mold assessments?
Yeah, look, you can. If you hire the person, you're probably going to have to pay for them. And so mold in most cases is going to be demonstrably obvious. It's in most cases pretty visible. The issue where we have mold reports most commonly will be where we see someone that's had mold treatment and they're not satisfied, the mold's entirely gone. And then they're like, well, we want to do parts per million tests and do swabs and all this sort of stuff. And that gets quite expensive. The tribunal will be open to it if there's grounds to suggest that the treatment's been inadequate or improper or not in compliance. We don't have in Australia a specific standard. There's an American sort of code, but it's not adopted in any formal way here. So I would suggest that, don't go and get expert reports unless you really need them. But to start off with, mold is now defined as an urgent repair. So if you see like a patch of mold and you're like, that's going to grow, or that's going to be an issue, or I've got asthma, or, if there's mold, urgent repair. And you can get into VCAT 2 days, take your photo, it's mold, and then you got to work out, well, what's the appropriate treatment? So if you have something particularly in mind where you're like, I don't want you to just paint that over, I want you to do this, well, then you're probably going to need to justify the remedy or the solution that you're wanting as compared to what they might be suggesting. So you do need to be specific about what you think the appropriate remedy is, and you can do some research on it, but do be careful about spending lots of money on unnecessary reports. A free quote, if you can get a free quote in a report, great, if it's free, but if you can't, I'd be just getting into VCAT to raise the issue as soon as, so it doesn't grow. It's not good for anyone. It's not good for the rental provider that, mold proliferates through their property either. Yeah.
And like you say, that's the time to take those photos and bring those photos.
Absolutely. And it is also important that people take a pragmatic approach to go, well, the mold's happened. Why has it happened? Because you can have leaking pipes behind the walls. You can have, rising damp through the floors because there's inadequate ventilation. There are a lot of poorly designed houses, but sometimes it can spontaneously happen because they're there. We get plenty of agents saying, oh, but you've got to open the windows in winter. That's your fault. Or you're putting your towel on the floor. You've caused the mold. You can just ignore that and go through with the urgent repairs, and that can be dealt with at VCAT.
Yeah, great. We've got a number of questions about the market rental increases and how is that excessiveness gauged?
Yep, sure.
Excessive increase, but also what's the success for people who challenge it? Is it generally a brick wall, or is there some...
I'd love to know that myself. I had a drafted FOI that I'm not sure where it's at the moment. So the factors are set out in section 48 specifically. So they go and look at similar properties in the area. So if I live in Wyndham, for example, I'd be going and looking at, and I live in a 3-bedroom, I'd go and look at a 3-bedroom. I'm in brick house, they'll compare it to a brick house. So it's like for like. But when they come out to do the assessments, if there's mold in the bathroom, the other house is assumed to be in good repair. So you should be pointing out really any defects, any issues, that you can. But it is still a harsh test. So anecdotally, we've seen a number of people, you might get like a $50 increase. Your chances of challenging that successful if your rent was relatively low, it's probably not great. But equally, if you've got a $200-300 increase, then you're like, that seems a bit much given that you've done nothing in the last 10 years. So what we encourage people is that there's not a lot of harm in getting the report. So the rental provider might get a copy of the report as well. And if it says it's not excessive, the renter can actually still go to VCAT and make their case. So what we do encourage people is that when the Consumer Affairs Inspector comes, go and do your own research, go and find the similar properties yourself and go, look, this is how much they're charging. It's not worth that much. But as I said, I don't want to be unrealistic either, in the sense that there are, like, the CPI is a driving factor. They don't necessarily consider the RBA's interest rates as a factor, but they do consider the value of the property. Interestingly, values of properties are said to have gone down, and certainly there's no mechanism for a rent decrease notice or that as a specific factor. They look at previous rent increases as well as a factor, but strangely enough, in the 1958 Act, it did consider the hardship of the renter. They would say, oh, this, so it's strange that we lost that one, unfortunately. So there's obviously going to be a lot of discussion around what fairness looks like in rents, because it's clearly hurting Victorians.
Yeah, and I will briefly say, from a VCOSS advocacy standpoint, and I suspect Tenants Victoria as well, there are jurisdictions like the ACT that do have rental caps and have a framework around that, and we're trying to have that conversation with government at the moment about doing something similar. Vincent has a question. This should be an easy one. I'm just wondering if VCAT is resuming compensation hearings yet.
They are looking at a specific list for bond and compensation in person. So that's sort of something we don't have the full brief on at this point. But the hope is that they want to try and get them done. So that's one of their major backlogs, and it's a huge hurt for renters that are trying to hold out against the arbitrary claim from the rental provider. So we're hoping that they will start to sort of fast track them. With things that have got time pressures on them, you've got to be really careful about making sure you've got a fair hearing. We really encourage people to be organised, put everything in a book, mark clearly down the bottom, page number, descriptions, the dates when they were taken, just so you can get sort of a smooth hearing. But they are looking at getting into bond and comp pretty aggressively, I think, but likely at an in-person level. So that's one of the changes we're sort of watching in terms of post-pandemic. We are hoping that they will keep some level of people being able to attend on the hearing, because we know if you have to go to hearing and you'd miss a day's work and then you get adjourned, then you got to go back, that's 2 days worth of work, where if you're already under rent arrears and you're casual, it's no good. So, yep.
Yeah, great. Okay, another question. We'll whip through these ones now before the clock.
Sure.
Can you explain head lease agreements? i.e.,
Sure.
If an agency is listed on the lease, how can these be challenged? Who advocates for the client?
Sure. So just for everyone's benefit, so when we talk about a head lease, you got the person, for example, that might own the property, and then they will lease it to, say, someone here. It could even be the Director of Housing. So you might have Director of Housing here, or Homes Victoria, and then the Homes Victoria has a lease, and they are given permission to sublease or sublet or subrent, whatever language you want to use, down to the person down here. So each person has their respective rights against the other. So if there's a repair issue, the renter can still make their application per normal against Director of Housing, and then if the Director of Housing hasn't had anything done, or they're not able to, authorised or otherwise, then they have to then in chain make their application up here. A more efficient way of doing it with subleasing, whether it's private or involves any social housing, is to actually do what they call joinder. So you ask for repairs, and then what the the head tenant can do is that they can actually join in the owner, and so that everyone's in the same room. That's the easiest way of doing it. And there's a specific provision that was implemented in the reforms to allow them to do that. You can always do it. It's under Section 60 of the VCAT Act, and just get everyone in the same room. So it really makes no difference in a theoretical sense, but practically there's a lot of finger pointing. You did this, you're responsible for that. And you have the similar issues with owners corporations, which are responsible for common areas. So when in doubt, we really encourage people to get everyone in the same room, use that joinder mechanism. If you want to know how to do that, you can call us again to talk about it. That's probably the most efficient way. But subleasing is quite common. It can be complicated when it does involve a rebate. So that's another dimension of it. But yeah, you can treat it as a normal tenancy. Same with, so there's really not any major differences in terms of if you're in social housing and you've got urgent repairs, 2 days, you run off to VCAT, it's the same thing. So we really encourage people not to wait around. Squeaky wheel gets grease.
Yeah, fantastic. Sharon and Robin have both submitted, I guess, clarifying questions. In your original presentation, you were referencing financial advisors and access to
financial counselling. Yes, I did. I always get picked up for that. So financial advisors tell you how to make millions of dollars and all that sort of thing, and that's not what they do. It's financial counsellors. My apologies. That's a rookie mistake. Yes, so financial counsellors, and they are such an important asset as people are under more and more pressure to make ends meet. We know that lots of people are going to food bank and other places that they've never been before. And I really want to try and normalize that for people of just going, this is what you do when things are really, really rough. I know my own bank account is a hell of a lot tighter than it used to be. So it's something which I think we need to build solidarity. I mean, in times like this, similarly post 1923 Spanish flu, coming into a depression, it was about community drawing together and surviving and understanding the nature of democracy, that we the people should not be starving in Australia. Yeah, great.
Question here about the CCTV that you mentioned. Lauren asks, does someone need to be experiencing family violence or to provide evidence of it to have CCTV installed?
No. So you can do it just as a general security measure. There is a particular provision that talks about family violence, but there's also a particular provision that talks about security. So I don't see any ground why that would be the case. If you're looking at doing a hardwired system, it may be relevant around the withholding of consent. But in both cases, I think people are well justified to want CCTV. I think it provides, if you want prosecution for a breach of an intervention order, you want evidence. It's a beyond reasonable doubt sort of threshold. So that CCTV is really essential. It's important that people understand as well, like just going down to Bunnings and buying something is quite different from a system that's professionally installed. There's all sorts of light angles. The main thing I'd encourage people is test it. Test that the system works and gives you the evidence that you want, because you don't want to go, oh, I think I've got it, and then find out there's a bloody tree growing in front of it or something like that. But no, you don't need an IVO.
And speaking of going down to Bunnings, Katarina asks, what if a renter does an urgent repair, like replaces a hot water system or something themselves, and then gets it certified, or it's up to scratch? Is that enough? And can they ask for reimbursement? Can they claim it?
Yep, you can. I can do works. I'll have to double check this. It's $2,500 or $2,800 GST inclusive. You can do those works yourself and then get reimbursed. You need to make sure that you've reported it in writing to the rental provider. The reason we don't encourage people to do that is because A, the cost can be significant. B, you become responsible if your tradies stuff up anything else. And C, once you've got that money that's out of your account, you then have to go to VCAT, get an order. And if you've got a really bad landlord, they go, oh, I don't have any money, I'm not going to pay you. And then you're chasing money. So yes, it is an option, one of the options under Section 72 and 73 of the Act, but we don't encourage people to do it. It can just become unnecessarily complicated.
Yeah, great. And maybe the last one before we do a bit of a wrap up, can people that have been declined a rental property, can they ask for a reason why?
They can ask. Yes, unfortunately, that's a facetious answer. Yeah, you can ask, but there's no obligation for them to disclose. It's a bit like jobs, why didn't I get the job? It is helpful to ask. There are some really not so smart agents that will make inappropriate comments that tell you that they're discrimination grounds. In most cases, they'll say, oh, it's just the landlord's right. So one of the things, if you think you've been discriminated against and you want to raise the issue, you can actually engage the Human Rights Commission for reconciliation. It's not going to get you the property, but it it does force them to have a dialogue about what happened. Usually the cases where we see that type of discrimination is where they say, oh, you're approved from the property. Then you come in and they see something about your particular characteristics, or, you know, they find out something about you and go, oh, no, the landlord's changed their mind. They no longer want to let the property, and then you see it back on the market or something like that. So they're the ones which are probably the telltales. But yeah, there's unfortunately not a right where they have to tell you why you weren't successful. Equally, if I was to be more strategic, you just go and knock on the door and see the people that actually got the property. Be aware that there is rental bidding, that renters are not strictly prohibited to make the offers. But I think there's some arguments around whether or not them accepting an offer that's above the advertised amount is essentially still breaching that term, but we'll have to wait and see. So it is a hard game, and we know that renters are competing against each other for what is an essential service, and that's the exact opposite of what an essential service should be.
Yeah, and that brings us right back to the start. You won't be surprised to know the results of that poll were that actually accessing and finding a property is the #1 issue that people are experiencing. Ben, thank you so much today for your expertise and your time, your generosity, and sharing your knowledge. Like I say, we're going to distribute all the resources from today. There'll be, including Ben's slides, there'll be a full captioned video recording. And I will also flag we have other sessions in this series coming up in the near future. We'll include details of those after this event also. When you leave the session today, as I see some of you are doing sneakily now that I'm wrapping up, you'll be actually diverted to a survey. We always want to know how we went, what we can do better. So please give us a little bit of feedback and your suggestions for future events as well. So from everybody at VCOSS, thank you, Ben. Thank you for attending. Hopefully we see you at another event shortly. Goodbye.